Talking, please.
So this is the first of a series of webinars on selected aspects of international law and African Union law to be organized by the African Institute of International Law. As you may know, the African Institute of International Law is an independent educational and research institution based in Arusha, Tanzania. It was established in 2012 by the African Foundation for International Law in close collaboration with the government of the United Republic of Tanzania. And it started its operations in 2015. The Institute is dedicated to the building of African capacities in the field of international law and to the consolidation of the rule of law in the continent in general. Why a series of webinars? As you can imagine, the educational and training activities of the Institute have been affected by the COVID-19. And since all these activities were carried out in the past in person and involved the travel, presence, and participation of lawyers from all over the African continent, the Institute had to shift its activities online and continue with the skills development and training activities in the form of training courses, online training courses, and webinars. The webinars are thus designed to be part of the activities of the Institute, and they are designed to provide an avenue for substantive engagement and continuous learning for African scholars and practitioners in the fields of international law and African Union law. So you can look forward to monthly webinars on various aspects of African Union law and international law, and you can always consult the website of the Institute to find out about the theme of the next webinar. The website of the Institute is AIIL-EADI. That is the acronym in English dash the acronym in French. So you can always find that, or you can simply Google African Institute of International Law. The theme of our webinar today is investment treaty arbitration involving African states and state entities, key issues. The key words here are investment treaty, arbitration, and African states. Those are the three key words. And of course, we know what are the key issues, but I'm quite sure that the speakers will elaborate on them. But I would like to mention three key issues on which I hope the speakers will enlighten us, but they can, of course, add other issues to those three issues very quickly and in a telegraphic manner. The first issue is the issue of the applicable law. Do African states scrutinize? And by applicable law, I mean the investment agreements themselves and international law, whether it is public international law or private international law. Do African states scrutinize the investment agreements which they sign and conclude with others? Do they have the capacity in international law to be able to check what they are getting into as far as the applicable law is concerned. The second issue is representation. Representation before the arbitral tribunals and representation in the tribunal itself. Do African countries have the capacity to have their own council represent them before such tribunals? And do they appoint African arbitrators to the arbitral tribunals in which they participate or they have to participate? The third issue is the issue of the venue of the arbitration or arbitral tribunal. Are they held when they concern African states and state entities? Are they being held in Africa, or are they delocalized? And if they are delocalized, which we know is the case, is most often the case, what are the consequences for the African states and state entities? Do the people of Africa know about the results of those arbitral tribunals? Are they aware of the outcome of those tribunals? Can African scholars know what happened in arbitral tribunals concerning their own countries and their state entities? So I just put these questions on the table with respect to these three issues, but I'm quite sure that these are not the only three issues. And we have 4 speakers today who are well known in the field of arbitration and who are also at the same time scholars in the field of international law. The first 2 keynote speakers, whom I will introduce right now, are Professor Kawar Qureshi and Mrs. Dayamana Diawara. And then their speeches will be followed by the commentaries of Professor Adelardus Kilangi of Tanzania and Madame Huguette Yvonne Ekume of Gabon. So let me introduce, first of all, the first 2 speakers. Professor Kawar Qureshi is a QC, Queen's Counsel, and specializes in commercial litigation, international arbitration, and international law, and practices from Searle Court, London, as well as McNair Chambers in Qatar. He is a visiting professor in commercial law at London University, and he is consistently identified as a leader in his fields of practice. And he has represented more than 70 states in arbitral proceedings and has also appeared several times before the International Court of Justice. And he has also represented a dozen African states in arbitrations. Mrs. Dayamana Diawara is the director of the International Court of Arbitration of the International Chamber of Commerce for dispute resolution services in Africa. She was previously a counsel at the Secretariat of the ICC Court for 5 years. Mrs. Dayamana is also a practitioner, and she practiced in the office of Dentonis in Paris before joining the ICC Court of Arbitration. She is a scholar, and she lectures in the Master 2 program in international commercial law at the University of Paris-Nanterre in Paris, near Paris. And she is a member of several professional networks. I will give the floor, first of all, to Professor Kawar Qureshi, and I will remind him that we have 20 minutes for each speaker. Professor Qureshi, you have the floor.
Judge Youssef, Your Excellencies, ladies and gentlemen, it's my pleasure and honor to join you for this webinar, where we are hoping to identify the issues that continue to vex African states and African parties in the context of a very important area of activity, namely bilateral investment treaty disputes, arbitration. The format of the presentation will cover bilateral investment treaties and then also address the way in which bilateral investment treaties affect African states. And what I'm about to say in the introduction is probably familiar to many of you, but bilateral investment treaties are used by investors to protect against the risk element of investment. They can also use contractual provisions, sovereign guarantees, bank guarantees, and insurance. Bilateral investment treaties began their life in more than a century ago, but the first recorded bilateral investment treaty was of 1959 between Germany and Pakistan. There are over 3,000 bilateral investment treaties in existence at present, and they can sometimes be underpinned by a multilateral regime, such as the Energy Charter Treaty, a regional free trade agreement such as the NAFTA agreement, or a mechanism for dispute resolution as provided by the United Nations body, ICSID, the International Center for the Settlement of Investment Disputes, which is housed in Washington and came into existence in 1966. Now, what is the purpose? As I indicated, the purpose ostensibly is to provide foreign investors with a level playing field, where the state, the host state, promises the home state that it will not use its sovereign power with detrimental effect to the foreign investor. Now, the presentation I'm sharing with you now is a very condensed version of a much more detailed presentation, where I will take you through the standard clauses in many BITs, and the example I've provided in the more detailed presentation, which will be shared with you, is from the China-Nigeria Bilateral Investment Treaty, which came into effect in February 2010. There are 8 aspects of bilateral investment treaties that I want to highlight for you, and most of these are similar in all of the 3,000 treaties with slight variations. The first and critical aspect is what qualifies as an investment. There are various decisions of investment treaty tribunals that have considered this question, bearing in mind that one of the major advantages of a bilateral investment treaty is that it enables the foreign investor to go straight to an international arbitral tribunal, where the foreign investor appoints one arbitrator. The state, so long as it understands the process, and I'll come to that shortly, appoints an arbitrator. The proceedings take place, often 5 years, 6 years elapse. There are challenges to jurisdiction, to arbitrators increasingly. The arbitrators may decide on a question of jurisdiction, and if it's within a framework such as ICSID, there may be an attempt to annul that challenge, decision. There may be challenges to the arbitrators as to whether or not they're independent and impartial, and then there may be a determination on liability. Has there been a breach attributable to the state, which leads to quantum? What qualifies as an investment? It's a very broad definition, every kind of asset. And then you'll see in investment treaties that there are some examples of assets, including shares, concessions. Who qualifies as an investor? The treaty will define an investor as a natural person, a national, or a legal person. Now, much has been made of the fact that some states are being used to springboard, to provide a way into a state because they have a bilateral investment treaty in place between themselves and a host state. Simply setting up a company which costs very little without a commercial presence or business activity seems unfair. But in many of these treaties, there is no requirement for presence or commercial activity. Is that an abuse or not? Well, I leave that for you to consider, but it's a reflection of the way in which this area has developed. And coming to the first point that Judge Youssef very, very rightly highlighted, and it's the underlying theme of this presentation, it's a regret on my part, unfortunately, in my 32 years of practice, having represented many African states and also appeared against them for foreign investors, that time and time again, even now, I'm acting for 3 African states. There is a lack of engagement with the agreements, whether it's a contract or a treaty that the state binds itself by. As a matter of international law, ignorance is no excuse. It's the same for domestic law. That really needs to change. There is no excuse. For decades, we have been able to access learning. And now that we're speaking to all of you on the internet, there simply isn't no excuse for state authorities, state attorneys to fail to acquaint themselves with the fundamentals so that when they sign an agreement or when they enter into a treaty, they understand the consequences. So those are the definitions. There are, in essence, two key elements of protection. One is identified as the fair and equitable treatment standard. What does that mean? It means that the legitimate expectations of an investor should not be undermined by the state by changing the law, the regulatory framework. There ought to be transparency, non-discrimination between the investor and nationals. The state's judicial framework ought not to deny justice. That, in essence, is fair and equitable treatment. Another standard is expropriation. When, after the Second World War, there was a spate of nationalization, the states in certain countries sought to take back control of assets that former colonial powers had appropriated to themselves. They believed that they were entitled to do so because these were national assets which were subject to the sovereignty of the state. When they were taken back, the foreign entities, often created by the colonial states, cried expropriation. And it is in the context of such cries that bilateral investment treaties were developed. In fact, it was in the 1950s, the nationalization of what was called Anglo-Iranian Oil Company by the Iranian government, that the UK Foreign Office made moves to develop bilateral investment treaties, then reflected in 1959 by the German government and its BIT with Pakistan. There are 2 types of expropriation: direct, where the state effectively takes over the assets, very few and far between, and there's indirect, called creeping expropriation. Now, expropriation is permitted so long as it's accompanied by prompt, adequate, effective compensation. In the absence of compensation, it's unlawful. How is the compensation to be calculated? It's the open market value of the asset just prior to expropriation plus interest. A most favored nation clause, in essence, allows an investor who is taking advantage of an investment treaty between their home state and the host state to look at other treaties entered into by the host state, which may contain greater protection, and in essence, cut and paste those provisions into the treaty between their home state and the host state. And they can be a cause of great surprise to a state. My first ever bilateral investment treaty case was in 1995 for a Greek national, when I was only 3 years in practice, where we were looking at most favored nation clauses in other treaties to take advantage of them against the Ethiopian government for the foreign investor. And it came as quite a surprise that this could be done in the 1990s, but it's now established, subject to the state, the consent of the state being manifest to allow the most favored nation clause to be imported in this manner. What is an umbrella clause? It's not to protect you against a rainy day. An umbrella clause, if it is a part of an investment treaty, it says something to the effect that the state shall honor its obligations. That has been interpreted by bilateral investment treaty tribunals to mean that where the state has directly or through one of its emanations entered into a contract, a breach of the contract is elevated into a treaty breach. It doesn't matter that the contract includes its own dispute resolution provisions before the domestic courts or other courts, it becomes a treaty breach. The dispute resolution clause of the contract is critical. This will provide for arbitration, typically ICSID, UNCITRAL, and may also contain a negotiation provision. And then the last 2 points, damages. How are they calculated? The damages can be substantial. The biggest claim that's at the present moment being the subject of vigorous challenge by Russia involves a $55 billion award against the Russian Federation in the context of the UCOS issue, where an oil company and its assets were allegedly taken unlawfully by the Russian Federation. Now, that is in contrast to what was in 2003, the biggest ever claim brought against a state that was for $7 billion against India, all about a power plant brought by General Electric and Bechtel, US companies, where I had the privilege to represent the Indian government, and that was in 2003. 7 billion, we settled it for about 100 million, and then 55 billion in 2014, an award against Russian Federation. There are in many contracts clauses called stabilization clauses and renegotiation clauses, in essence, to try and prevent the state from changing the tax laws, the regulatory laws, stabilization clauses, renegotiation clauses, in the event that the state changes the contract to the detriment of the foreign investor, and a requirement to renegotiate in good faith. Now, arbitrations with African states and state entities, the point that I want to refer to next. And before I do so, I wholeheartedly agree with the observation of Judge Yusuf. Now, I consider myself very fortunate, and I believe we're all very fortunate and privileged that we have Judge Yusuf sitting in the International Court of Justice as a shining example of how Africa can engage most effectively with international law. And I just hope that the presence of Judge Yusuf will inspire many more of you to embrace learning when it comes to international law arbitration, so that Africa does not continue to be disadvantaged in terms of representation at the level of arbitrators or the level of counsel. Africa, as we'll see when I take you through the slides, features significantly in investment treaty disputes, features significantly in commercial arbitrations, but is woefully inadequately represented. Now, in the 1990s, there were around 4 or 5 cases per year before ICSID. That then exploded in around 2010 to 44. In 2020, 54 cases, literally 1 a week, registered in the International Center for the Settlement of Investment Disputes, mostly arising out of bilateral investment treaties. And so far, there have been around 178 ICSID arbitrations against African states. That's a fifth of the total. And when we look at the caseload of ICSID, we are hovering around a fifth to a quarter of all investment treaty disputes before ICSID involving African states, yet, and Middle Eastern, North African states, and Sub-Saharan African states. Yet, astonishingly, despite a quarter of the arbitrations involving those states, only 4 to 6% of the arbitrators are from Africa. Now, this is lamentable from my perspective, because one of the virtues of arbitration, as is extolled, is that it is meant to address international issues. It's meant to provide a comfort zone for parties, international parties, and address the needs of the users. Now, if a quarter of the arbitrations, bilateral investment treaty arbitrations, involve African states, it simply is unacceptable that there are less than 5% of the arbitrators from Africa. How on earth can the understanding and the context of Africa, the difficulties that Africa has faced post the colonial era, the lack of resources, the lack of development in this area, be understood by arbitral tribunals largely comprised of lawyers from North America, Northern Europe, for whom using the internet, being able to engage with people swiftly, efficiently, is commonplace. Not being able to understand that internet access is very limited, that documentation is not recorded and retained in the way that it could and should be. How are they supposed to understand the cultural context, the pressure that exists to rush to sign a contract because of the eagerness to invite foreign investors, the lack of due diligence, the lack of proper scrutiny of foreign investors? How are they supposed to understand that? The astonishing rate of return that is available to these investors in the extractive industry sector and in infrastructure development that's taking place in Africa. Now, in 2017, ICSID produced an Africa-specific report, which showed that almost 80% of the investors in Africa were non-African, and more than half of the arbitration claims that were brought were successful in whole or part in terms of claims against African states. Now, that is very, very important. That means that more than 10% of the claims that are brought against African states succeed in a finding of liability. What are the key issues? The point that I want to be able to conclude on in the time that's available for African states. And in my view, there are 8 in the way that Judge Yusuf has quite rightly flagged up, and we must remind ourselves. There are challenges representing states and state entities wherever they may be from. I've represented around 70, including the UK government, the US government, Russian government, African governments. At the moment, I'm representing 3 African states. I've got a hearing in 10 days for an African state before the English courts on a very large arbitration. And the problems that I see from African states are essentially magnified in terms of inability to deal with deadlines, inability to engage in due diligence, review of documentation. And that all plays out very badly before arbitral tribunals. So, first point, contract drafting phase. Is the state going to be made a party to the contract? Will it waive its immunity? Is it going to be bound by confidentiality? A point that Judge Yusuf made. Many of these arbitration agreements insist on confidentiality. In the investment treaty context, confidentiality is less of a problem, but in commercial arbitration, most of the arbitrations take place in comfortable 5-star hotels, and the awards are subject to confidentiality. Even when they're challenged, there are requirements of confidentiality. Now, is that right, where hundreds of millions of dollars may be awarded to a foreign investor, and it's the nationals of the state that suffer? How is the state selecting counsel? Is it right that it always selects large international law firms, which, with respect, and I've worked with all of them, are not interested in capacity building? My own objective, I'm acting for the Kenyan government at the moment before the Kenyan courts on a constitutional matter. I believe passionately that it's my responsibility to engage in capacity building. So when I'm appointed as a counsel for foreign states, I make it a point to work with the local lawyers, the government lawyers, in the hope that in some way, shape or form, whether it's through training, actual training, or just sharing knowledge with them, that capacity building can take place. So it's vital that you select counsel in a way in which you can build capacity for your own state, and that you select counsel who are competent for the issue in question, as opposed to counsel that will be decimated by a very experienced international team. Arbitrators, why are you selecting your arbitrator? They must be independent, impartial, credible. The procedure, do you understand the procedure? The disclosure obligations. please do not fall foul of your disclosure obligations. If you have not retained documents, this will be interpreted as withholding documents. Corruption allegations are increasingly commonplace in international arbitrations. There may be much cause for allegations to be raised, but time and time again, the state authorities, for whatever reason, fail to deliver the evidence. Don't forget that now claimants are often having recourse to third-party funders, essentially businesses that stand behind claimants to push through a claim as aggressively as possible. And last but by no means least, one of the benefits of arbitration is the ease with which arbitration awards can be enforced against commercial assets of states. That means your revenues from sales of your natural resources, your commercial assets, your civilian airplanes, your ships, your properties. So please do not believe that somehow you can bury your head in the sand, ostrich-like. These arbitrations have fundamentally serious consequences for you, as I've seen, acting for foreign investors, freezing assets of states. I just want to give you two case studies, just very recent, an ICSID case against Gambia, July 2020, an attempt to challenge the appointment of an arbitrator by ICSID. Gambia failed to engage with ICSID. There was a time period, a timeline within which Gambia had to appoint its own arbitrator. It didn't, despite having been warned, despite having received formal notification from ICSID and the claimant. Once the arbitrator was appointed, Gambia cried foul, this is unfair. Too late, ICSID said. You had an opportunity, you were aware, you didn't engage, now you're stuck with an arbitrator that ICSID has appointed for you. That cannot be right, but of course, Gambia having signed up to the investment treaty and the ICSID process, it's taken to have accepted the potential for ICSID to appoint an arbitrator. Another example, Sierra Leone versus SL Mining, a hopeless challenge was brought to the jurisdiction of the arbitrators before the English courts. And the judge concluded that the challenge was obviously unarguable. Now, having challenged the arbitrators on jurisdiction in an obviously unarguable manner, once that arbitration proceeds, will the arbitrator's mindset be affected by this hopeless challenge? Whenever you appear before a court, whether it's the international court, a domestic court, or an arbitral tribunal, always remember the power lies with the decision maker. And if you are challenging the decision makers in a hopeless manner, they're human beings. You're likely to create a perception, whether that's right or wrong. To try and negate that perception is difficult. Concluding observations. The fact that states are increasingly active on the commercial plane means that there's more and more arbitration. It's the default process for dispute resolution for foreign investors. It is absolutely vital for those who are acting for African states and state entities to navigate the arbitral process effectively. They're not doing so. And how can we achieve that? A very strong proactive effort is necessary to build capacity within all African states, to ensure that they understand international law, arbitration, investment treaty arbitration, and that they are properly represented both at the arbitrator, platform, and council in international arbitration. Thank you very much for this opportunity to share these thoughts with you.
I thank Professor Khawar Qureshi for his insight and for the extremely important points which he has brought into the discussion, because these are points which we will discuss afterwards, and I'm quite sure that the panelists, the commentators will take them up. These are all issues which require a urgent attention on the part of African states. And of course, capacity building is at the heart of it all. And that is the mission and the objective of the African Institute of International Law. So I will now give the floor to Mrs. Diamana Diawara, who, as I said, is both a scholar and a practitioner and has a lot of experience in the field of arbitration affecting or involving African states. Ms. Diawara, you have the floor. We can't hear you. We can't hear you, Ms. Diawara. We can't hear. Can you switch on?
Can you hear me now?
Yes.
Oh, right. Okay, sorry. I was saying thank you very much, Judge Yusuf, and good morning, ladies and gentlemen. I am delighted to take part in today's webinar, and I would like to start by communicating my most heartfelt thanks to the African Institute of International Law, in particular, of course, Judge Yusuf and Ambassador Sani for inviting me to address you today. I hope that my modest contribution to today's conversation will help shed some light on the general issues and challenges that African states and state-owned entities are facing when engaging in arbitration in relation to foreign investments that they host on their soil. So I would like to, if you allow me, share my screen and go over a brief presentation. I would just need a few seconds for that. Can you see my screen? Yes? Okay, great. So as I was saying, I would like to take you through some of the key issues that in my experience arise when it comes to investment-related disputes and arbitration, and in particular, the experience of the ICC. In a first part of my presentation, I would like to go over, in a broader sense, the investment treaty arbitration under the ICC rules, and then come to the specific issue of the particularities that African states and state-owned entities may encounter in their engaging into this type of disputes. First, a few very brief figures about ICC. The ICC International Court of Arbitration has been in existence for almost 100 years, since 1923. And as you can see on the chart, on this chart, last year in 2020, the ICC has received a record number of 946 newly registered cases, arbitration cases, with the exception of 2016, but that year the number of newly registered cases was particularly inflated due to 100 of class arbitration cases introduced in the US, so that's an exception. Again, the important information here is that the ICC in 2020 has received over 946 new cases involving a number of different parties, and among them disputes involving African states. When discussing and when covering the issues of relating to African states and state-owned entities in investment disputes before the ICC, I think it's important to make a distinction, and there I would propose two types of disputes that the ICC in its caseload is encountering. The first type, in which African states and state-owned entities are involved with respect to the investments that they host on their soil, are contract-based arbitration. So in essence, these are not labeled as investment arbitration because they do not arise out of a treaty mechanism being triggered. The second type of arbitrations that the ICC court here are purely investment treaty-based arbitrations. Now, I do think that it's interesting to address both, and although today's discussion has been labeled to focus mainly on those disputes that are investment-based, the reality is that when observing, and in my experience over the past 8 years at ICC dealing with case management in Africa, when you look into those contract-based arbitration, they actually almost, I would say, all of them that involved African states or state-owned entities do relate to foreign investments on the soil of an African state. So but in the form of a contract, and the arbitration is triggered through the clauses of a contract. And one point that I will come to in the second part of my presentation is precisely that the challenges and the issues, procedural issues in particular, that are observed when it comes to African states and state-owned entities are mostly the same, whether you're looking at contract-based arbitrations or investment treaty-based arbitration. Now, the caseload of the ICC court is involving not only African states, but more generally states and state-owned entities, is majoritarily composed of the first type, as I was saying, of arbitration, but the number of treaty-based investor-state disputes administered by the ICC court is constantly increasing in a steady manner, and has increased over the past 10 years. In particular, in 2012, a study of the OECD showed that between 10 and 20% of the bilateral investment treaties concluded between 1998 and 2010 allow for ICC arbitration for the resolution of investment disputes. That's an interesting information, because what it demonstrates is that the ICC is in a way the third most common forum for investment disputes after ICSID and UNCITRAL. And that, I think, is a trend that we do see or we foresee to go increasingly due to the fact that there is increasing, I would say, reluctance from a number of states to engage in ICSID arbitration. The first investment treaty arbitration under the ICC rules was initiated back in 1996. And there has since been a total of 43 investment arbitration cases administered by the ICC court. In addition to that, the ICC court also acts as an appointing authority whenever a member of an arbitral tribunal, and in general, that would be the president of the arbitral tribunal, is not designated jointly by the parties or according to the mechanism provided for under the treaty, then the ICC court might be called upon to make such an appointment. And that, for example, is the case in UNCITRAL treaty-based arbitration cases. Looking at the breakdown, the regional breakdown of those treaty-based investment arbitrations, one really important information here for our discussion is that Africa and North Africa come as the first region in the world for the ICC investment-based and treaty-based there, I'm talking about arbitrations with 15 cases over the past, since 1996. The second very close region that comes in terms of the number of cases is Central and Eastern Europe. And then following closely are Latin America and the Caribbean. You can see on this slide that Central and West Asia or North and West Europe are much less concerned by those investment treaty-based arbitrations filed with the ICC. Now, I would like to address the procedure for investment treaty disputes under the ICC rules. You've heard from Professor Qureshi a very useful reminder of the basic procedural issues in investment treaty-based arbitrations. The interesting thing under the ICC rules is that there is no particular different procedure that is dedicated to investment treaty disputes, and that is because the ICC rules, as they are flexible enough to adapt to this type of disputes as much as they can cover contract-based disputes. Now, despite that, in 2012, the ICC court has decided to incorporate a number of modifications to its rules in order to take into account the particularities and the needs of arbitrations involving states and state-owned entities, and more specifically to facilitate the administration of treaty-based investments. Those modifications, I highlight three on this slide, are in particular the prima facie determination of a claim that ICC court and ICC and the Secretary General of the ICC are allowed to do under the ICC rules. When it comes to treaty-based disputes, basically the rule at the ICC is that the preliminary screening that the court or the Secretary General normally do would not be exercised in order to allow for an arbitral tribunal to go ahead and do directly the competence jurisdictional determination of its jurisdiction over the alleged investor and the existence of the investment. Now, there has in the history of the ICC treaty-based disputes, there has been two occurrences where there was a derogation to that rule that the ICC would not exercise the prima facie determination. And these were cases in which basically an alleged private investor had introduced a case against a state in one of the instances, against not a state, but against a private party on the basis of an investment treaty. And that private entity had alleged the fact that the respondent in the dispute was basically had substituted itself to the state, and that's why it could use the investment treaty to direct the claims to that party. The ICC court, looking into this specific scenario, had decided to reject the case at the stage of the prima facie determination, and that the case would not move forward to be determined by an arbitral tribunal. But that, as I said, is a very, very limited exception to the rule that the ICC would not apply articles to the prima facie determination under Articles 6, paragraph 3 and paragraph 4 to states and state-owned entities involved in treaty disputes. The second modification that was brought to the 2012 ICC rules to take into account the particularities of treaty disputes is Article 13.4, paragraph A, and that relates to the appointment of the arbitrators in those particular cases. And the variation that was introduced at the time was that instead of going through the normal selection process of arbitrators by the ICC when selecting the president of a tribunal or sole arbitrator, whenever there's no alternative agreed upon by the parties, the ICC court decided to introduce a derogatory mechanism because its default mechanism goes through national committees of ICC court, and those national committees are mostly composed of business organizations in different countries. A number of states over the years had expressed the fact that they were not comfortable with that, and they were perceiving it as potentially a risk of lack of neutrality. Because of that, the ICC court decided that whenever a state or a state party would be involved in one of its disputes, then the ICC court would solely retain the right for appointment without going through this process of addressing first a request for appointment of an arbitrator to a national committee. For example, in a case where there's a need to appoint a Nigerian arbitrator, the ICC court would normally go through its national committee based in Nigeria. If that the Nigerian party that fails to appoint an arbitrator happens to be a state or state-owned entity, then the ICC court would not go through its national committee, but proceed with a direct appointment of the arbitrator upon selection of the president of the court. The last particularity, I would say, tailor-made provision of ICC rules in 2012 concerning treaty-based dispute was with respect to the emergency arbitration provisions that were introduced in the ICC rules at the time, and for which the ICC court decided that treaty-based arbitrations would systematically be excluded. And for that, it introduced a requirement that the emergency arbitration provision could only be triggered by an applicant when towards a responding party that would be a signatory to the contract containing the arbitration agreement. And by introducing the signatory element, into the emergency arbitrator provision, the ICC effectively excluded treaty-based arbitration. That was done again in order to respond to a concern of a number of states that were saying that, and I'll come to that in a few minutes. And those states were expressing the fact that the particularity of their administrations would not allow for a very short emergency proceedings to take place in 15 days, although it's at the ICC, it is not an ex parte procedure for obtaining emergency relief or conservatory measure. It still is a very short procedure of 15 days, and the particularity of the state with the length that it might take sometimes to look into a given case, be able to instruct counsel, would not allow to participate in such a short procedure. So taking that into account, the ICC court decided to exclude treaty-based arbitration from the scope of ICC emergency arbitration. The last point I would like to address with respect to the particularity of the ICC procedure when it comes to investment treaty disputes are the most recent modifications made to the ICC rules. A new version of the ICC rules was entered into force on 1st January this year. And again, a number of tweaks were, and they are minor, but they I think are important to make ICC procedure more suitable to investment treaty-based disputes. And so the first of those changes is again to Article 13, which touches on the appointment of arbitrators, and basically you have it on the screen. The new provision here indicates that the members of an arbitral tribunal sitting on an investment treaty-based dispute would no longer have the possibility to be of the same nationality as that of the parties. And here the consideration was one of neutrality and just following the trend of ICSID in terms of the nationality of the arbitrators involved in a given dispute based on a treaty. The second modification to the rules in 2021 with respect to treaty-based disputes is Article 29.6. Paragraph C. And again, this touches on emergency arbitrator provisions that I was describing earlier, with simply codifying expressly what was already the practice of the court under the previous article that I exposed. And the last point, which is a very interesting one, I believe, is actually not in the rules themselves, but the ICC note to parties and arbitral tribunals, which provides that for those cases that touch on that are based on that are treaty based, there is the possibility for amici curiae to intervene in the dispute. Now, coming to the actual issue of this discussion today, what are the issues and challenges, I guess, that African states face when entering into investment treaty-based or contract-based disputes in ICC arbitration? Here, I would try to touch, and of course, on the points that Judge Yusuf has raised when doing his introductory remarks, and of course, I had them already pinned in my presentation. The first point that I would like to address is the geographical aspect of the origin of parties involved in ICC disputes. As you can see on your screen, the African continent accounts for a little less than 7% of the total of the parties involved in ICC disputes. These data are for 2020, so there's a slight decrease in the northern part of the continent. But overall, if we look at the past 10 years, there has been a steady increase in the number of African parties involved in ICC disputes. Now, the particularities of those African parties, you can see here that about 20% of states and state-owned entities represented in ICC arbitrations are 20% of the parties involved in ICC arbitration are states and state-owned entities. When you look at the African region, these figures go up to 25%, and that is telling. And in my experience over the 8 years that I've spent in case management, doing case management of African disputes, I can tell you that a very important share of my work was dedicated to African states and state-owned entities. I would like to stop and mention that those African states and state-owned entities, when involved in ICC arbitrations, are most of the time on the responding side of the dispute. So most of the time, indeed, they would be called into that dispute by, as I was saying in introduction, a foreign investor. Now, what are the issues that we're facing? I have categorized them in two groups. First, the procedural issues, and then the jurisdictional ones. Whether the arbitration is initiated against an African state on the base or a state-owned entity on the basis of a treaty or a contract in relation to an investment, a foreign investment, we do see similar procedural behaviors that tend to be observed on the part of the state party. And these, I've tried to cover them, and I will provide some specific example. The first and most difficult issue that we encounter is that of the lack of participation. I'm really happy to have Ms. Sekume today with us from Gabon, who will be, I hope, able to share her experience, in the sense that I think that she's part of as the head of the contentieux de l'État in Gabon. She's part of those group of states that belong to the exception, meaning that they actually do participate in the disputes where the state or state-owned entities are called as respondent, and don't just wait for the case to proceed in their absence and then wake up with, quotation mark, when it comes to the enforcement. But the lack of participation is still, when it comes to state and state-owned entities in Africa, is still an important problem that is being faced, and in particular in investment treaty disputes. Another point that I think actually maybe even explains that first procedural issue is the difficulties to identify the correct administration within the state to serve with the request for arbitration. And for most of the requests for arbitrations are usually addressed to the ministry in charge of the particular area in which the investment was happening. So, for example, the Ministry of Transportation, the Ministry of Industry or Mines when it comes to mining. But often we see that the claimants and the private investors would omit to include in those requests for arbitration the representative of the Attorney General, which usually are the central office where the disputes concerning the states are concentrated and are being followed. And that does create difficulties for the state to properly be represented. So I guess here, one recommendation, at least from the point of view of the case management institution that I would have, is that the state needs to work on a system of better communication between its administration, among the administration, different administration, to ensure that the information is passed on correctly if the investor is not going to do the work of identifying who should be served apart from the directly involved ministerial offices who should be involved in the dispute. The next issue, an important one that Judge Yusuf has touched on when opening, is the question of the choices of the representation of the state. Here, I completely subscribe to what was said previously by Professor Qureshi. In most of those African cases, the choices made by the states are to go with outside counsel, international-based outside counsel. I do not necessarily think that that is a bad thing. However, what I think that it would be an interesting model that we see from certain states, for example, the state of Senegal does that, is to systematically have a pairing between if there is going to be an international team of representatives for the state, then there should be a local team to also be involved in that dispute, not just actually for capacity building purposes, which are extremely important. At some point, you know, the ability to represent the state has to be refocused in African hands. But I think that it's also because in a lot of those cases, and that comes to the first point that Judge Yusuf has addressed, the applicable law chosen, at least in ICC arbitrations, is often that of the African state and not an outside applicable law. So when that, and I'm not talking about, of course, international provisions that would apply in terms of determining the identity of the investor, the existence of the investment, etc. I'm talking here about the law applicable to the merits. Interestingly enough, while African states would forego the choice of the place of arbitration to be placed outside the continent, they managed to get the law applicable selected to be that of their country. Then the problem becomes, how does international counsel, non-African counsel, have proper understanding, reading of the applicable law and application within the case and plead it properly to the tribunal? And that has, when doing ICC, as you know, ICC court does the scrutiny of awards. And when we proceed to that exercise of scrutiny in those African disputes, in a number, too many of those cases, the ICC court comes to the conclusion that the arbitral tribunal ends up applying rules that do not belong to the law applicable. But because both council teams were not African council team, were not in the know with respect to the law applicable, they in a way tacitly modify the choice of applicable law by pleading under a different regime. So for example, if you have a case involving the law of the Democratic Republic of Congo, I can assure you that you will systematically see outside counsel pleading that case under either Belgian law or French law, systematically. But because both sides would agree would do it spontaneously, then the arbitral tribunal finds itself in a situation where it has to apply that law, which becomes the consensual choice of the parties. So, of course, in the scrutiny process, the ICC court will try to draw the attention of the tribunal to that incoherence in a way between the initial choice of the parties in the contract and what the procedure what has emerged while the procedure goes on. But I guess the best way to tackle that is simply to involve a counsel who understand the applicable law and are able to properly plead it in front of the tribunal. I see that I'm seriously running out of time, so I will move to the next two slides that I have, and I will stop there. The place of arbitration, I was mentioning it. Interestingly enough, in most investment treaties dispute that were referred to ICC, the place of arbitration is not predetermined, but it often, the provisions of those treaties often allow for a selection by the investor between two different places. So one example you have on the screen would be, for example, that the dispute would be seated either in London, UK, or in Tripoli, Libya, in a case, obviously, that's an example pulled out from a treaty involving the state of Libya. When that case is presented, however, we systematically obviously see the selection go towards London. In those cases where the place of arbitration is not predetermined under the ICC rules, there's no default place of arbitration. The ICC rules allows for the place of arbitration to be selected by the court in any given place. But, and that's important, despite the fact that there's no written rule in terms of selecting the place of arbitration, what I've noticed looking into those investment treaty cases is that whenever the court proceeds to the determination of the place of arbitration, it will select Paris. I think that I only found one exception to that rule over all of the cases that I have reviewed. And I think the reason, obviously, for that is that the court would go for a neutral place of arbitration, also one that is arbitration friendly, obviously, for the arbitration award with the concern that the arbitration award ultimately be capable of being enforced. And so there again, indeed, there could be a reflection done on the choice of the place of arbitration at the time of entering into those treaties, in particular, because nowadays, I think nobody would dare say that the arbitration legal framework in most African countries would not allow for them to be qualified as safe seats. Now, of course, there is still tremendous work to be done in terms of training of the judiciary to make sure that the law is then that those appropriate arbitration law are then properly applied by the judiciary when it comes to reviewing or examining enforcement of arbitral award, rather. I will stop here. I haven't been able to address the jurisdictional issues, but I'm sure that in the Q&A, we will have a chance to come back on that. Thank you so much for your attention.
I thank Ms. Dewara for an extremely enlightening intervention, and I think that I thank her for taking us through the particularities of the ICC procedures for investment treaty dispute and how those particularities affect African states and the key procedural issues and challenges facing African states. And I'm quite sure that the participants will have questions for her, but I'm also sure that the two panelists on whom I'm going to call now will also find fertile ground for commenting on her introductory remarks and those of Professor Kawar Qureshi. And both of them have actually raised a number of key issues which should be addressed by African states. And they are international practitioners. They are acquainted with what happens at the international level. And they have been involved with both of them in many arbitrations in which also African states are involved. But now we will move to the African practitioners themselves, and we will hear from them, because in a way they were interrogated actually by the presentations of Professor Qureshi and Mrs. Dewara. And they have told us, for example, about non-participation, about appointment of foreign counsel, the pros and cons, about delocalization, the consequences of delocalization, about the applicable law, etc. So I hope that the two practitioners who will now take the floor will also address those issues and address them from the perspective of the African states and state-owned enterprises. And first of all, we have Professor Adelardo Schilangi, who is the Attorney General of the United Republic of Tanzania. As his title indicates, Professor Kilangi is a professor of international law and has actually been teaching for quite a long time in various universities in Tanzania before being nominated Attorney General of the Republic of Tanzania. He also served as a member of the African Union Commission on International Law between 2009 and 2015, and was the president of that commission from 2012 until 2014. The second speaker that we have today as a commentator and panelist is Madame Huguette Yvonne Ekoumé. Madame Yvonne Ekoumé est depuis avril 2017 directrice générale de l'agence judiciaire de l'État du Gabon, le couronnement d'une longue carrière passée à plusieurs postes de haute responsabilité dans l'État gabonais. En tant que directrice générale de l'Agence judiciaire du Gabon, elle a participé à une dizaine de procédures arbitrales devant différentes juridictions contre l'État gabonais. Je vous souhaite la bienvenue à vous, Madame Ekoumé, et à Monsieur le professeur Kilangi. And I will now give the floor to Professor Kilangi. I cannot see him. I hope he can turn on the video so that we can see him and take the floor. You have the floor, Professor Kilangi.
But do you hear me? Do you hear me, everybody?
Yes, we can hear you, of course. But
Maybe
we don't
just
see you. We don't see you.
Yes, I've noted that, teacher. Just a minute so that I sort that out. Just a second.
You are not trying to hide from us, are you? And I wish to remind you, Professor Kilangi, that each one of you has about 10 minutes because we have already run over the time. So if you can keep to those 10, 12 minutes, I will be most grateful. You have
Thank
the
you
floor.
very much, Judge Abdul Kawi. I was contacting with my technical people because I'm in Dar es Salaam. I was supposed to have taken this conversation in Dodoma. So I'm in hosted office. And so I was trying to link up with my host so that they clear things for me. But if you do not mind, we'll start talking, and then when the technical person comes, they'll help me clear so that I am visible.
Please
Would that
go
be
ahead.
okay?
Please go ahead. Yes, please go ahead.
Okay. Thank you, and apologies for that inconvenience, because it's always good if you see somebody who is talking to you. I'll begin by saying I take so much delight for the invitation that was extended to me to participate in this conversation. And I'm equally delighted to meet, though virtually, Judge Yusuf Abdulkawi. We have linked in so many occasions, including those training seminars on international law organized by the African Union and the Office of Legal Affairs of the United Nations. I have taken note of the three issues you have flagged. The question of applicable law, the question of representation in the tribunals, the question of venue or place of arbitration. And I would like to congratulate and thank so much the two speakers who spoke before me, Professor Kureish and Mrs. Diawara. On the three issues, my remarks would be brief on two, and then I would want to focus on one. So I'll be very brief on the question of representation in the tribunals. That I tend to agree with most of the observations that have been made, because this is one of the areas where we need to do more. However, I'll also be quick to point out the fact that there is an element of cost when you talk about representation. The second thing is the question of venue, where I also tend to agree with most of the observations that have been made by the two speakers. But I was just quick to Sorry, my technicians are telling me that I cannot start the video because the host has stopped it. So it should be probably on that end, on some other end.
Well, I will ask the organizers to do whatever they can in order to help you with the video, if it is actually in their ability to do so. I hope that they will be able to help you. I'm quite sure they will try. But continue, Professor.
All right, all right. So on the question of venue, place, my having, taken note of the observations made, and as I've said, agreeing partly, my advice would be that I think African countries need to put in place one center for arbitration. If that would not be possible at the regional level, because we have the regional economic communities, we have the regional integration initiatives, each could put in place a center, because if a center for arbitration is shared amongst a number of countries, that generates confidence and trust and comfort in it. Otherwise, I have taken note and agree with most of the observations made on those areas. Now, I come to the third issue. That is the question of the applicable law. To be honest, to me, this is the fundamental issue to be addressed before everything else, before the question of representation, before the question of participation, before the issues of procedure, before the issues of venue. And I just wish that Professor Qureshi had time to address himself sufficiently on this. Because when you speak about investment, you have key issues that you have to consider, all of which come down to the question of applicable law. What law is applicable to those issues? The question of admission of investment and treatment of that investment is ultimately the question of law. Then the second thing, the question of management of host countries, the countries that host investments. And African countries would mostly fall in this category because they're not really much expected to export investments. How do you manage those countries? It comes to the question of law. Then the management of investors or companies involved in the investment. It's the question of law. And then you have the dispute, the question of dispute settlement. It also comes to the question of law. So these four parameters would finally come to the question of law. And I would not hesitate to make my preliminary observations on this area that, and it's evidenced in much of the scholarly work, that when it comes to management of host countries, there's always been a push, for a myriad of assurances granted to investors. So the host country should not do this, not do this, not do this, not do this. But when it comes to management or regulating of investors, it has always been very difficult. And investors have mostly not wanted really to be that much regulated in the same way host countries have they have wished host countries to be regulated. That's my very general observation. With that, it will be necessary for us to briefly go into the history of development of the law. We talk about the applicable law. We probably need to briefly go into development of that law. We know very well when attempting to develop principles of law that would govern and manage investments, the starting point was customary international law. But then within customary international law, there were problems, as we all understand, of controversies and disagreements, and mainly between investment exporting countries, and mostly developed countries, and against investment hosting countries, mostly developing countries. So these controversies and disagreements led to polarization and division of points of view, which then made customary international law a very difficult field or source of international to apply to investments. And that's where there was this attempt to move to develop multilateral legal framework and trying to develop multilateral treaties and agreements. But as we all know historically, that there were problems and challenges in this attempt, in this endeavor, such that it has not been possible actually to develop a coherent and comprehensive multilateral legal framework on investment. And I'll come to that briefly. And that's why there was this move to bilateral investment treaties. So bilateral investment treaties, we know, did not come by accident. There was a reason, and that reason is there was failure on the platform of multilateral legal framework or multilateral investment treaties. And then afterwards, there was this also further move to state investor agreements. So that's where we mostly are. And when we talk about legal framework governing investments, we'll mostly talk about bilateral investment treaties, or we talk about state investor agreements. And this, I think, mostly what the two speakers have alluded themselves to. So now, what is the key problem here? And this is my very personal view, but it comes from a long experience, I consider, of dealing with these matters, both at the academic and the practical levels. Because, previously I used to teach, and then when I was appointed Attorney General, I was faced with real life situations on this area. In my view, the biggest problem, as far as the applicable law is concerned, emanate from the fact that we had challenges that had existed in the area of customary international law. And I've pointed out to the disagreements between the investment exporting countries and investment hosting countries. There is a list of principles of customary international law, which are well known to us, but I will just list a few quickly. The principle of national treatment, the principle of minimum standard of treatment, the principle of state responsibility, the principle of respect for acquired rights, the principle of diplomatic protection to corporations, even though that has not been widely, used, the principle of fair and equitable treatment. Most problems lie with this principle. The principle of pacta sunt servanda, the principle of good faith and prohibition of abuse of rights, principle of clausula rebus sic stantibus. This is the question of a change of circumstances, and the question of exhaustion of local remedies. Now, as I've said, there have been disagreements, there have been controversies existing in those principles. And these disagreements, tended to take, a polarized trend where investment exporting countries will take their view on these principles, while investment hosting countries, mostly developing countries, African countries inclusive, would tend to take the opposite view of that. And actually the evidence of that is simple. The evidence of all what I'm saying is simple. We saw it in these many attempts to develop, as I said, coherent, comprehensive treaties to govern investments, where most of the proposals that were made by developed countries were rejected by developing countries, and most of the proposals equally made by developing countries were rejected by developed countries, led by the OECD countries. So this is clear evidence of the divisions and disagreements I'm talking about when it comes to principles of customary international law. And I would cite some of these principles where actually the disagreements have been greater than in others. The principle of fair and equitable treatment, and especially if it is associated with the principle of minimum standard of treatment. And then the principle of state responsibility. You see, on fair and equitable treatment, we know very well. The problem has been, what is the scope of things that would come into the ambit of what it would be considered as fair and equitable? And then the state responsibility, again, what would be the list of things that, would fairly come under the ambit of state responsibility, which if breached, a state would be considered to have breached its obligations. Clause rebus sic stantibus, the question of change of circumstances, then the question of exhaustion of local remedies, the question of good faith and the prohibition of abuse of rights. The question being is there really good faith when treaties are being negotiated, or when agreements are being negotiated? So again, in my view, this problem was further exacerbated by trying to import these principles of customary international law into bilateral investment treaties and state investor agreements. You see, these principles of customary international law, with their controversies and disagreements involved therein, have finally been imported into bilateral investment treaties and state investor agreements. In many ways, sometimes clandestine ways, for which African countries, for lack of capacity, have had difficulties, noting that this clause, I'm importing now in this investment agreement, actually is linked to the principle of fair and equitable treatment. It's actually linked to the principle of state responsibility. It's actually linked to that principle. And that now points to the question of lack of good faith, because these facts are supposed to be laid bare on the table, that here we are introducing this clause in this trade agreement or the investment agreement. Actually, the import of it is this. And now, from the point of view of international law proper, I also have a problem, because when you import principles of customary international law into bilateral investment treaties and state investor agreements, you would think that that would lead to the effect, similar effect as codification of customary international law. And as you all know, when you have codification of customary international law, then you have certainty on that particular principle of customary international law. Because, when you have it within the realm of customary international law, you would have these controversies, disagreements. But when you codify it, you'd be expected to remove all these controversies. But that's not what is happening. And the reason as to why I think that that importation of these principles into BITs and state investor agreement does not lead into crystallization of those principles is because, tribunals would constantly make reference to the interpretation and understanding of those principles in the same way, they were typically in the realm of customary international law, and you had these controversies and disagreements as to, what each principle actually entail. Now, as I've said, tribunals, once they see that there is a clause which is akin to a principle of customary international law, take comfort in going back to the interpretations that you had within the realm of customary international law and adopt its own interpretation. But probably by doing that, it would find itself taking sides, you know, in that polarized arrangement.
Sorry, Professor Kilang, but may I ask you now to conclude?
Okay, so let me conclude. I pointed out to specific principles of customary international law, which pose a great challenge to developing countries, African countries inclusive. Fair and equitable treatment is the first principle, which for me is the biggest culprit. Everybody will agree with me that most of the cases brought before arbitral tribunals are based on breach of fair and equitable treatment principle. And for cases that have been brought on the basis of breach of fair and equitable treatment principle, you know, we know that developing countries, African countries inclusive, have lost by more than 90% on those fields, which then tells us that there is a problem with this principle. We might need to revisit this principle and define the clear boundaries of it, that such and such things would fall within the realm of what is fair and what is equitable, and all other things should not be considered to fall within that ambit. The same goes for state responsibility. You know, what things exactly, you know, would constitute state responsibility and what things would not be considered as importing responsibility on the part of the state. And if we do it by a similar way, like codification, as I mentioned earlier, then that would save us a lot of problems. But also, the principle of clausula rebus substantive was the question of change of circumstances, you see, which in most negotiations would investors would not want really provisions to that effect inserted in these investment agreements. I would strongly recommend that in good faith, you know, in the spirit of good faith in negotiations, that such clauses be included. But the last thing, quickly concluding, that again, if these negotiations of you know, investment agreements are to be done in good faith, so the question of equality of arms during those negotiations has to be looked into, because really I am troubled when you know, companies, you know, negotiate with governments and states on a clear platform of inequality of arms, and then companies take comfort in that. I'm really troubled. I would think that you know, if good faith really prevailed in negotiation of these agreements, then at least attention should be paid at the fact that one side might be weaker, might have less capacity, and therefore that might put it in a position of jeopardy in the future. May I stop there? Thank you so much.
I thank Professor Kilangi, and I thank him for bringing actually into the discussion the African practitioner's point of view and the difficulties that the African countries are encountering and the challenges that they face with respect in particular to applicable law, because he put the accent there, and I think that there is a lot to discuss there, because he finds that the inclusion of certain standards which are of customary law origin is where the problem lies. But then one has to ask oneself, of course, I agree with him that there is an issue of equality of arms when the negotiations take place. The capacities of the parties are not equal. But then, of course, once the agreement is concluded, The issue is also the interpretation of the agreement. And who interprets that agreement at the arbitration tribunal? And there we have to see whether actually African states are represented in that interpretation. And African perspectives are reflected in the interpretation. Because if all the interpreters are actually people who come from outside Africa, then the kind of perspective is that Professor Kilangi would like to see in the interpretation of those standards will not be there. So I think that these are all interconnected: representation, applicable law, and interpretation and application of the standards. They are all interconnected. So now our next and last speaker is Madame Huguette Ekoumé. Elle est la directrice générale de l'Agence judiciaire de l'État du Gabon. Et je lui donne la parole parce qu'elle va aussi nous éclairer en ce qui concerne le point de vue du praticien africain qui doit tous les jours s'occuper des problèmes, des résolutions des différends concernant les investissements et participer aussi, représenter son pays devant les tribunaux arbitraux. Je vous donne la parole.
Merci, monsieur le juge Youssouf. Je voudrais déjà remercier toutes les personnes qui sont ici présentes, mais remercier notamment les organisateurs de ce webinaire d'avoir bien voulu associer la voix du Gabon à travers son agence judiciaire de l'État pour échanger sur cette thématique aux enjeux multiformes. Aussi, je voudrais quand même confesser ici la difficulté qui est la mienne à prendre la parole dans le cadre de cette table ronde après de brillantes interventions des panélistes de haut niveau. Et qu'à cela ne tienne, je vais quand même m'aventurer à commenter tout ce qui a été dit pour dire que dans la première présentation, le professeur Kawar a justement présenté les aspects essentiels qui gouvernent le droit des investissements qui, il faut le dire, est majoritairement issu des traités bilatéraux de promotion et de protection des investissements que concluent finalement les États entre eux. Il a d'ailleurs, et à juste titre, abordé la question relative aux clauses de protection qui constituent un élément important de ces traités, et plus encore pour les investisseurs qui sont toujours à la recherche d'en bénéficier. Dans un second temps, dans une seconde partie de son intervention, le professeur a mis l'accent sur l'arbitrage d'investissements étrangers qui implique les États africains ou les autres entités morales de droit public. Son exposé a été finalement le résultat d'une étude détaillée avec des statistiques fort édifiantes. Un travail d'experts illustré par la suite par des études de cas qui retracent certains contentieux des États africains soumis à l'arbitrage international. On a bien noté lors de son intervention qu'il a bien fait observer les nombreux dysfonctionnements enregistrés dans la participation de nos États, justement dans le cadre de cet arbitrage. Revenant à l'intervention de Madame Diamana, elle a dressé un tableau sur la situation du nombre d'affaires portées devant les instances arbitrales au cours de ces 10 dernières années. Tableau qui révèle finalement une augmentation exponentielle du nombre des procédures d'arbitrage qui concernent également nos États africains. Elle a par la suite précisé que l'arbitrage pouvait être fondé sur un contrat d'investissement, tout comme cet arbitrage peut être également fondé sur un traité d'investissement, avec des exemples plus concrets. Et tout comme le professeur Kawa l'a fait, Madame Diawara est revenue sur les carences observées, les dysfonctionnements qui sont pour la plupart imputables à nos États et pour lesquels je crois que des efforts doivent être apportés. Mesdames et messieurs les panélistes, à la suite de ces différentes interventions dont le contenu nous interpelle à plus d'un titre, et vous comprenez d'ailleurs pourquoi, nous avons noté la nécessité pour nos États à mieux nous organiser pour une meilleure participation dans le cadre de ces arbitrages. Et je profite de cette tribune, d'ailleurs, pour solliciter l'établissement d'un partenariat avec l'Institut africain pour nous accompagner, nous, États gabonais, dans le cadre de renforcement des capacités, dans le cadre de renforcement de nos capacités, justement en vue de mieux nous outiller pour une meilleure gestion également de ces nombreuses procédures auxquelles nous sommes engagés. J'espère, à la fin de cette communication, avoir l'accord justement pour l'établissement de ce partenariat. Mais à côté de cela, il y a lieu quand même de souligner que la surprotection, nous l'appelons ainsi, nous l'observons dans le cadre des dossiers qui nous sont soumis, la surprotection de l'investisseur engendre finalement un déséquilibre certain et qui est souvent à l'origine de lourdes condamnations prononcées contre nos États dans le cadre des arbitrages qui sont menés et qui, en fin de compte, développe la méfiance de nos États à l'égard de ce mode de règlement des différends. Cette méfiance est d'autant plus amplifiée par les coûts financiers non négligeables des procédures d'arbitrage sur les finances publiques de nos États. Devant ce qui apparaît comme une préoccupation de nos États, qui, faut-il le rappeler, sont en quête d'un développement certain et harmonieux de leur territoire et du bien-être finalement de ces populations, il apparaît de notre point de vue de parvenir à une réforme du régime juridique et le champ d'application des traités d'investissement et partant du mécanisme de règlement des différends. Parce qu'il faut le dire, il serait opportun d'envisager un arbitrage à visage humain, car les investissements qui sous-tendent ces conventions, objets de litige, sont destinés à offrir un mieux-être aux populations de nos États. Il faut qu'on en tienne compte, et de plus en plus. Pour revenir au cadre de l'expérience pays, en ce qui concerne le Gabon, il y a lieu de noter qu'à ce jour, au titre de l'arbitrage des investissements, 7 procédures ont été portées devant le CIRDI et une procédure devant la Cour permanente d'arbitrage, dont la majorité est fondée sur l'accord OCI sur l'investissement. On a également plusieurs procédures qui ont été portées devant la CCI et Madame Diawara est là pour en témoigner. Il faut dire que conscient des difficultés posées dans la mise en œuvre des procédures issues de ces traités, le Gabon a lancé depuis plusieurs années un certain nombre de réformes visant à mettre en place un cadre juridique et institutionnel attractif pour les investissements. À titre d'exemple, on note la création d'une agence nationale de promotion d'investissement avec un guichet de l'investissement chargé à titre exclusif d'accompagner les investisseurs dans leur démarche, mais aussi il y a à côté de cela l'élaboration d'un code des investissements. C'est vous dire qu'on essaye déjà de mettre en place un régime juridique qui puisse nous permettre de mieux suivre finalement les contentieux qui pourront découler de ces nombreux traités auxquels nous sommes partis. Au vu de ce qui précède, nous pouvons nous avancer sur les perspectives suivantes en termes d'amélioration. Pour nous, il y a lieu comme recommandation à procéder finalement à la révision ou à la renégociation périodique de tous les accords d'investissement signés par les États africains. Il faut insister notamment sur la suppression des clauses dites pathogènes. Ces clauses posent véritablement problème au moment de la survenance des litiges. Dans une autre mesure, nous suggérons la réécriture des clauses de protection insérées dans les traités d'investissement. Leur formulation imprécise, et ça a été relevé ici, et floue a engendré de nombreuses procédures contentieuses qui ont, dans la majorité des cas, été perdues par nos États. Il serait judicieux, justement, de limiter la portée de ces clauses dans les accords d'investissement que les pays concluent. Dans une autre mesure, nous suggérons la rédaction pour les États africains d'un modèle, peut-être pas unique, mais d'un modèle national de traité d'investissement. Et cela s'inscrira dans le but de clarifier et de circonscrire le contenu des normes de protection afin d'éviter les interprétations arbitraires trop larges qui interfèrent souvent et le plus souvent avec les politiques publiques de développement. Il s'agira également d'inclure des dispositions pour assurer les investissements, pour s'assurer que les investissements contribuent activement au programme de développement durable de nos pays. Monsieur le juge Youssouf, je n'ai pas été longue, je crois que ce sont les quelques commentaires qui m'ont paru nécessaire de formuler à la suite des interventions de mes prédécesseurs. Je vous remercie pour votre aimable attention.
Je remercie Madame Ekoumé, and of course you have all heard what she has said, and I really thank her for sharing with us her experience as a person who represents her own country in arbitral proceedings and the difficulties and challenges which she faces. And she has suggested a number of measures which African countries should put into place in order to meet those challenges. And I note in particular her suggestion that a model agreements and model treaties should actually be elaborated for African states so that when they sit at the table with their foreign counterparties, they don't have to look only at the model agreement brought by the capital exporting countries, but they can also put on the table their own model agreement. And the discussions and the negotiations can take place on the basis of that. Because as Professor Kilangi said earlier, there is a lack of equality of arms. But if you have two documents of equal importance on the table, you don't have to sign on the dot the document brought by the other side. You also discuss on the basis of your own document. So that's a very important consideration. And I also note her what she said about the partnership with the African Institute of International Law. And I think that, of course, that partnership is there. The African Institute has been created for that purpose. It is at the disposal of all African states, including Gabon. And I am quite sure that now that Mrs. Ekoumé is in touch with the African Institute, she will be able to work directly with them with respect to the training of and capacity building in Gabon, because I'm quite sure that the Institute is ready to help Gabon with respect to this. And I hope that she will continue being in touch with the Institute. We have come to the end of the presentations, and I thank all the speakers. And now we have a number of questions. And we have about 10-15 minutes for these questions. I have seen the questions that have been posted both on the chat box and on the question and answer box. So there are a few questions for Mrs. Dewara, but I will take two of them. One of them is why are exit and ancestral procedures preferred more as mechanisms for dispute resolution in investment arbitration or investment treaty disputes than the ICC court? And the second one is would Article 13(6) discourage the ICC court from appointing an African presiding arbitrator when the investment dispute involves African states? So maybe you could address those two questions. And then a question for Professor Qureshi. Do you agree that ICSID is largely pro-investor rather than pro-state? So I will let Ms. Diwara go first, and then Professor Qureshi, and then there are a couple of questions also for Professor Kilangi.
Thank you very much, Judge Yusuf. I'm happy I am not the one answering to the question asked to Professor Qureshi. So on the first question that is put to me with respect to the reason for more referrals to ICSID and UNCITRAL rather than ICC when it comes to investment dispute, I believe the reason is a historical reason in the history of investment treaty arbitration. Obviously, with the entry into force of ICSID, a number of states around the globe had adopted this dispute resolution mechanism for the investment disputes, and that was the original one. And so naturally, I think the center, the ICSID Center, has over the years been the one registering the highest number of investment treaty disputes. Slowly, a number of states have started turning to alternatives. I believe historically, again, because a number of states that would be qualified as developing states found ICSID as not necessarily responding to their needs and being more of a Western organization, being one of the Bretton Woods, the resulting Bretton Woods organization with the World Bank. So I think that basically in a third wave, some states have been looking for alternatives to ICSID or UNCITRAL and have started turning to institutions that they already knew through their disputes in commercial, on the commercial side of their activities or contract-based activities. And that explains why ICC has a lesser involvement in investment treaty disputes. But as I said, this is a changing trend, and at ICC, we're clearly hoping to see more of those disputes come our way. And again, the ICC rules are perfectly designed to allow for that. On the second question, a very interesting one with respect to the appointment of arbitrators, which allows me actually to complete my presentation.
Briefly,
of course, the purpose is not under Article 13(6) of the new ICC rules, not to be able to appoint African arbitrators within the scenario of an African treaty-based case. Of course not. The purpose, however, would be that if, and let me take a concrete example, I have an investment treaty-based dispute between a Turkish investor and the state of Libya, the arbitrators involved in that case would have none of the nationalities of the parties. So there would be no Turkish arbitrator, no Libyan arbitrator. But of course, if a suitable candidate is identified from Algeria, from Morocco, from Ghana to sit as the president of that arbitral tribunal, that would be a possibility for the ICC court. So again, the idea is not to exclude African arbitrators, it's simply to insert more neutrality, avoiding citizens for a given state to sit in cases where the public interest of that state are being discussed.
Thank you very much, Professor Qureshi.
Judge Yusuf, thank you very much. The questioner just needs to look at the scope of investment treaties. There are 4 points here. Of course, the ICSID regime is intended to protect foreign investors. That's the whole point of it. But that's no excuse. The system has been in existence for 60 years. It's not good enough, with respect, for us now to blame legal systems of having been imposed by colonial powers. Why is it that Eastern European states have been able to embrace public international law? Former communist states such as China is at the forefront in developing model BITs. because it has understood the importance of engaging with systems, of building capacity. And that is the critical question here. It's, with respect, it's not good enough to blame legacies. It's vital now to engage. Why is it that the US and UK and EU states are very infrequently the subject of investment treaty disputes? Why? Very simply, because they engage, they negotiate, they review, they effect due diligence. That's why. Unfortunately, my experience over 30 years is that African states do not engage, they do not review, they do not negotiate, and they enter into agreements which are totally one-sided. Why blame the investor for taking advantage? Of course he's going to take advantage. That's the nature of a legal system. If you don't understand the rules, if you don't use the rules to your advantage, you will suffer. And it's not good enough, from my point of view, to blame international law or a particular framework, the investment treaty framework. The states seem to adopt an either-or approach. Either it's all an international law firm charging many millions of pounds, and then the flip side of that, the backlash against that is we'll do it all ourselves because we want to save costs. There is a halfway house. I've been advocating that, which is, of course, ensure that your domestic lawyers gain capacity and bring on board somebody who can help you gain that capacity. If I look, for example, at Tanzania, it has at least 7 investment treaty cases against it, probably claims several hundred million. I've got no doubt an international law firm would charge Tanzania a huge amount, but I can assure you, Professor Kilangi, that if it was an independent counsel working with you, you should use the power that you have as the client to negotiate properly, to ensure that you are served as best as can be by your counsel. It would not serve the interests of a state to say, we're saving costs, we're going to conduct this proceeding ourselves and face an international sophisticated law firm that will run rings around them. That is all I wanted to say. Thank you.
Thank you very much. And now there is a question for Professor Kilangi, actually, which takes it from where Professor Qureshi just left it, because the question is, how is Tanzania handling the cases pending against it before arbitral tribunals? And are the mistakes identified by the speakers being avoided? E.g., for example, the need to pair local counsel with foreign counsel. Professor Kilangi.
Thank you very much, Judge Abdul Kawi. I will start by going to the very questions that, a question that you have raised or asked Professor Qureshi, and then come back to the question of how Tanzania is handling these cases. In my view and understanding, many investors go to the ICSID or prefer the ICSID rather than the ICC because of the single most fact that ICSID cases would be based on bilateral investment treaties. So you cannot institute an ICSID case if there is no basis on the bilateral investment treaty. Now, that takes us to the problems that I have talked about. Professor Qureshi talks about, making no excuses. But I said, if these negotiations were conducted, in good faith, then, the question of inequality of arms should have been taken into consideration. The problem here is bilateral investment treaties were negotiated a number of years before an actual investment came into place. So perhaps at the time of negotiating the bilateral investment treaty, some of the things had not come to light or were not clearly understood. And then the terms of those bilateral investment treaties are couched in generic terms. And when terms are couched in generic terms, you know very well, they're subject to very wide interpretations. And as I've said, and it has been scholarly analyzed and documented, tribunals would tend to take a certain trend in discussing and interpreting those terms. And therefore, a wide range of things may actually be brought into the ambit and then a state would most likely be found to have breached those terms. And I would not want to go to the previous discussion, which is connected to what I'm saying. Now, you go to the ICC, mostly cases are based on state investor agreements. Now, because these agreements were negotiated on the table and probably much attention was put to the negotiation, a care was exercised. And now you find that the trend is that if you pursued a case on the basis of a state investor agreement, the state would most likely win. But if you pursue a similar case, similar facts, same set of facts, you know, which has been instituted based on a bilateral investment treaty, a state would most likely lose. So we are aware of those realities and the facts. And as I've said, they've been well documented. These are not simple accusations that have been raised by Tanzania and the other countries. Now, how are we handling these cases? You know, we're handling these cases in the reality that I've talked about, because most of these cases are brought based on breach of terms of the bilateral investment treaties. They are not being brought on the basis of breach of the actual investor state agreements that we signed, where, you know, sufficient care was exercised. So we see that problem. We have tried to engage the best of the lawyers. But again, the question of cost I mentioned earlier comes into play. You know, one would have hoped that arbitration would be cheaper. But you see, you know, for a developing country like Tanzania, sorry.
Oui, nous.
Please go ahead, Professor Kilangi.
Oui, vous pouvez y aller, Professeur Kilangi.
Sorry, come again?
Oui, allez-y, s'il vous plaît.
Go ahead, Professor Kilangi.
Allez-y, Professeur Kilangi.
So I was saying,
allez-y, concluez. J'étais en train de dire, je disais.
My God, we have the French.
Je disais.
We have the French
sorry, the French interference.
Interfering again. Yeah, we have the French interpretation interfering again. Could the French interpretation use another channel? Est-ce que vous pouvez utiliser un autre canal?
Can you please use a different channel?
C'est l'autre qui doit m'envoyer la paire de langue pour que je valide.
Ah, okay.
J'ai été déconnecté et quand je suis revenu, l'autre.
Ça va maintenant. Okay. Judge, Professor Kilangi, please go ahead and conclude.
Yes. So I was saying, for one arbitration, we pay up to, you know, from anything from 5 million to 10 million US dollars to pay for the lawyers. Think of, you know, you have 10, 15 cases. That's a lot of money. That's so costly. And I was saying that one would have hoped that arbitrations would be cheaper. We are told this is alternative dispute resolution, so it's supposed to be cheaper to the actual litigation. But in our view, you know, arbitration has tended to be more costly for us than any other method. Definitely, we are addressing the question of capacity with the seriousness that it requires. And as we speak for now, we are handling most of the cases ourselves. You know, we have trained our lawyers, we have built their capacity, built their, you know, cultivated their experiences, and now we are handling these cases ourselves. However, the hurdles, which for me are so fundamental that I've mentioned, which emanate from, you know, their basis or origin in the bilateral investment treaties, which import principles of customary international law, which then allow tribunals to have a broader field of interpretation, is still the main problem. And it's not a cry for Tanzania only. It's well documented by many scholars. It's the cry for many developing countries. Can I pause there?
Thank you very much. One last question, and I give Ms. Diawara 1 minute to answer it. Could you elaborate more on the applicable law before the ICC? National law, public international law, private international law.
Thank you, Judge Yusuf. Under the ICC rules, basically, there is different levels of determination of the applicable law. Either it was chosen by the parties in their agreement, when it hasn't, and that's the case in most investment treaty dispute, since we're looking at scenarios where a private investor is initiating a claim against the state on the basis of a BIT without a pre-existing contractual relationship, then it falls on the tribunal to determine the applicable law. And what I was saying earlier is that, interestingly enough, we see tribunals in those cases using the process of the private international law determination in order to come to the selection of the applicable rules of law. When it usually then the arbitral tribunal will apply different sets of rules to the jurisdictional issues and to those pertaining to the merits of the claim. So with respect to the jurisdictional issues, in most cases that I've reviewed, the arbitral tribunal will apply customary international, public international law for the determination of issues such as whether the investor has made a protected investment, whether the investor can invoke the dispute settlement clause contained in another treaty through the most favored nation clause contained in the prime treaty, any issue of ratione temporis jurisdiction, for example, whether the investment treaty was in force at the relevant time when the investment was made. So all of these issues will be determined generally with respect to public international law. Before I stop there, I would just want to bring a slight nuance to Professor Kilangi's indication. Actually, bilateral investment treaty arbitrations can very much be dealt with before the ICC. I fully subscribe to Professor Kilangi's explanation that in the contract that states engage in, there's more care exercised, there's closer negotiation, but that's not to say that investment treaty arbitrations would not be capable of being determined before the ICC court, quite the contrary.
Thank you very much. And we are coming now to the end of this webinar. And I thank again all the speakers and all the participants. And I think that there are still a number of questions, but unfortunately we have run out of time and we cannot address all the questions today. What I may suggest is actually that we organize and that the Institute organizes more specialized and more focused webinars, one on applicable law in investment treaties, one on representation of African states before and in the tribunals, and one on the place of arbitration. Because I think that we should take the three broad issues one by one. We have taken everything together today, so we were not able to examine and analyze in an in-depth manner each one of them, but at least we have touched upon all of them. And of course, what we can take from all of this is that there are still a lot of challenges with respect to the issue of applicable law in Africa and with respect to African countries. There are still a lot of challenges with respect to representation. And there are still, of course, a lot of challenges with respect to the place of arbitration, because both of the lack of regional or sub-regional centers, there are certain centers which are now in Africa, but as Professor Kilangi said, maybe it would be better if African countries could have sub-regional centers like a center in the COMESA, a center in the SADC, a center for IGAD, a center for the sub-regional groups or the Central African countries, etc. And of course, the issue of enforcement, because we know the reason why many tribunals are delocalized is because they don't trust that the award will be enforced in African countries, you know, so that is also a matter that needs to be addressed. So we need to look into all of those, and I suggested that the Institute should look into the possibility of organizing more specialized, actually, webinars on these different things. But we actually, as far as these challenges are concerned, then everything comes down also to the issue of capacity and capacity building. Because Professor Kilangi said there is no good faith in the negotiations. But even if there were no good faith, we cannot say, of course, that there is no good faith always in the negotiations. But even if there was good faith, but one of the parties was less skilled than the other, then of course the lack of capacity and skills of that party will be taken advantage of by the other party. And that's what happens most of the time in the conclusion of investment contracts and in the conclusion of investment agreements. So African countries need to have the capacity to be able to scrutinize, to be able to engage in the negotiation, but they need the capacity. You need also capacity with respect to representation and also with respect to the interpretation and application by the tribunal. Because if you appoint your own arbitrator, who is an African arbitrator, you must make sure that this is a person who can actually pull his or her weight and who can help the tribunal understand the African perspective of interpreting fair and equitable treatment, etc., and all these kind of standards, and bring into the discussion the interests and the laws of the African states also to bear on the discussion. So I think that the African Institute will have to play an important role in that respect with respect to the capacity building, and I have no doubt that the Institute will play that role. And that's why I would like now to call on the rector of the Institute, Ambassador Sani, actually to conclude the webinar for us. Ambassador Sani, you have the floor. And we give you 5 minutes. Can we find Ambassador Sani? Or has he left us? Because I could see him earlier. Can the organizers help us find Ambassador Sani or tell us whether he's no longer with us so that then we can just close the session?
He's disconnected.
He disconnected some time ago. So we don't expect him to come back. Is that?
Yeah, we're trying to get him back on, but we don't think he can get back on before we close.
Okay. So I would like to thank again the speakers of this webinar. First of all, Professor Kawar Qureshi. Secondly, Mrs. Diamana Diawara. Thirdly, Professor Adelardus Kilangi. And of course, and I am very thankful to Madame Huguette Yvonne Ekume for their participation and for enlightening us, actually, on the issues raised by the theme of the webinar, investment treaty arbitration involving African states. So if Ambassador Sani is not there, then I will just declare the webinar closed, and I thank all the participants for their attention. The webinar is closed, and thank you very much.
Thank you. Thank
Thank
you
you very
much.
much. Bye-bye.
Bye-bye.